I believe that's our cue. Good afternoon and welcome to Facebook Live. My name is Amanda Powell. I am with Lone Star Legal Aid. I am a staff attorney with our fair housing team in our Equitable Development Initiative unit. And I am joined today by Delilah Oates, who is with US Vets of Houston. Hi, Delilah.
Hi, Amanda. Hi, I'm Delilah Oaks with US Vets Houston, the operations manager. I have been working in homeless services for about 15 years, working with different populations. Right now, I strongly and only focus on the veterans population. And we have several programs to include supportive services for veteran families. We have a transitional housing program, permanent housing for disabled veterans, and a permanent housing for chronically homeless veterans, and some other supportive services programs where we assist with utilities, jobs, mental health services. So we pretty much provide a wraparound service here at US Vets Houston.
Awesome. I'm so happy to be partnering with you today, and hopefully you could take away some information you can share with the veterans you work with, particularly those who are disabled. So let's get in.
Yes, I'm looking forward to it.
Thank you. So today we're going to be talking about disability accommodations in housing under the Fair Housing Act. And it's basically just an overview of what is called reasonable accommodation in housing. Specifically, we're going to be talking about the Fair Housing Act. We're going to be talking about what is reasonable accommodation, what's reasonable modification, how to submit a request, and what to do if your request is ignored or denied. Okay, so let's talk about what is the Fair Housing Act. You may have heard of this.
Yes.
The Fair Housing Act protects people from discrimination when they are renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in other housing-related activities. It protects discrimination by housing providers. And what I mean by housing providers, example of those people could be landlords, real estate companies, lending institutions, and home insurance company whose discriminatory practices are available to those who fall under protected class. So what groups or classes fall under protected classes that's covered by the FHA? You have race, color, national origin, religion, status, familial status, and disability. Particularly, we're going to be talking today about disability, that particular protected class being covered under the Fair Housing Act. The Fair Housing Act also covers most housing, which includes apartments, single-family homes, condominiums, manufactured homes, and others. So let's talk a little bit about examples of housing discrimination that's actually covered by the Fair Housing Act. So refusing to rent or sell a house, refusing to negotiate for housing, or making housing unavailable. And you may ask, well, what do those types of situations look like? Well, you might have, for instance, landlords setting different terms or conditions for the sale or rental of their home. You might have landlords providing a person different housing facilities or services, falsely denying availability of a rental unit, or advertising or making any statements that kind of indicate a preference or limitation on a protected characteristic. So like, for instance, families, and I've been involved with many different clients who have families who have also experienced some discrimination practices from apartments or landlords who might say, oh, we don't rent to, people who have 5 kids or individuals who are pregnant. That would be an example of discrimination under the Fair Housing Act. So let's talk about what is reasonable accommodation under the Fair Housing Act. And did you know, Delia, that disabled veterans have a right to request reasonable accommodation? And we'll talk about reasonable modification in a minute, but they have a right to request a reasonable accommodation based on their disability.
Yes, I'm aware, and sometimes we get pushback from landlords about reasonable accommodations. And I know you said about making housing unavailable. Sometimes they'll try to charge an additional charge and say this might be a difficult tenant, so they'll ask for additional monies to make it harder for the veterans to get into that unit. We have seen that, and then sometimes it's also with safety, just making sure that, and some of the units making sure that they have an elevator properly working and available for our clients to utilize. So I have seen those issues come up on many different instances.
Wow. So thank you for sharing that. I have those too, and particularly with the audience you cater to, mainly veterans. I'm sure a lot of them are disabled, and so being denied their reasonable accommodation really prevents a hardship for them. So I'm going to talk about what reasonable accommodation is, which it's under the Fair Housing Act, which protects disabled individuals and protects their right to request a reasonable accommodation in a rule, policy, practice, or service of a housing provider. The request is needed to afford the disabled individual equal opportunity to use and enjoyment of the home. And housing providers must grant reasonable accommodation if it's necessary to accommodate the disability and it does not create undue financial burden or administrative hardship. Refusing to grant a reasonable accommodation may be considered a disability discrimination. So let's talk about some examples of reasonable accommodation. And Delia, you gave some great examples of individuals or veterans who complain about these types of issues when they're requesting reasonable accommodation. Some of the examples I've listed is a building with a no pets policy. They must allow a visually impaired tenant to keep a guide dog. An example two would be an apartment complex that offers tenants unassigned parking must honor a request for a mobility impaired tenant for reserved space near her apartment if it's necessary to assure that she can access her apartment. Or three, a building that has several floors must permit a mobility impaired tenant to transfer to a first floor unit. So these are some examples for which a disabled individual, whether they're a veteran or not, may be able to request an accommodation where there is a policy where there's a policy of the housing provider that will require them to change their policy to accommodate that individual.
Let me ask you a question, Amanda. What about a service animal? I know we see a lot of veterans have service animals. Would that be considered a reasonable accommodation?
It is a reasonable accommodation, and it's something that you can request, and we'll talk about how to request a reasonable accommodation. But that is, for instance, comes up a lot with apartments that have a no pets requirement or a no pets policy. A service animal is not considered a pet. And so the these housing providers or landlords must accommodate service animals for individuals who need them. A lot of times the individuals who have service animals need to be able to have their animals for several different reasons, to help them with tasks or emotional support, whatever it might be. But those are related disabilities for which a person might have an emotional support animal, and the housing provider must accommodate that person. That's a good question. Thank you.
Thank you.
So let's look at reasonable modification. Now, have you ever heard of reasonable modification? or
Yes,
just reasonable accommodation?
I
Oh,
I have heard of reasonable modification as well.
awesome. I know this is one that people tend to not expand upon, or many people don't know about, but a reasonable modification is a structural change made to an existing premises occupied or to be occupied by a person with a disability in order to afford that person full enjoyment of their premises. So this actually differs from a reasonable accommodation in that reasonable accommodation is where you're asking the landlord to make a change in their policy, rule, or activities. In this instance, with reasonable modification, you're asking the housing provider to make some type of physical structural change to the premises. And some examples of that might be requesting the installation of a ramp. That's particularly important for individuals who are wheelchair bound and who need access, particularly like you mentioned in apartments that do not offer elevators. That's extremely important. Or a disabled individual might ask for the housing provider to install grab bars in the bathroom, which is also needed, particularly for those who are visually impaired or have some type of mobility issues.
Yes, and we had an instance once before, Amanda. We had someone that was hearing impaired, and they had to make sure they had the proper lights up just in case they had an emergency. So they had to make that reasonable that modification for that individual to make sure if something's going on, they can see the flashing lights for safety reasons.
Great, that's a great example because accommodations can be broad. I mean, it's literally based on what that person's disability is and what they need. And so there's so many examples of what a person might need that they might ask for an accommodation. So that's actually a great example of requesting a specific accommodation. It really is on a case-by-case basis. Everybody's not going to need the same thing just because they're disabled. So let's talk about who can request a reasonable accommodation or a reasonable modification. So it could be you or someone in your family who have a physical or mental disability, which includes, I've just listed here some of the conditions that might fall under disability: hearing, mobility, visual impairments, chronic alcoholism, AIDS-related complex mental retardation, all of these conditions that might substantially limit one or more of your life activity. Delilah, I know with veterans, they typically have experiences with burns, amputation, PTSD, brain trauma related injuries. Those would be considered disabilities because they all are conditions that may substantially limit their life activity.
Right.
So they would fall under being classified as disabled. So disability is also having a record of disability or even being regarded as having such a disability. So let's talk about how we can submit a request for reasonable accommodation or reasonable modification. The request should be in writing, though it's not required. I mean, the disabled individual can literally walk up to the housing provider, the landlord, if that's the landlord in his case, and just say, I need reasonable accommodation, and whatever that accommodation might be. Now, the thing to requesting with a reasonable accommodation, there has to be a link between the disability and the accommodation. So like, for instance, if you have some mental illness and you're asking for accommodations for, let's say, installing a ramp, there might be a little bit of a disconnect between you having a mental illness and requiring accommodation for the installation of a ramp. Whereas if you're, have some type of visual impairment and you're requesting a ramp, that's a clear link where the disability and what that person is requesting is related, if that makes sense.
Right. And how much documentation do they have to provide? Because some landlords, housing providers might ask for extensive documentation and might even say, hey, I don't believe you have this, you need this support animal, or you need this accommodation. You're just trying to be difficult. I mean, so when is it like, when do you get to the point and say, hey, I'm not providing you all this additional documentation that you're requesting for my accommodation?
That's a good question. So, and I actually included a note under in this particular slide about that. So unless it's obvious and apparent that the person is disabled, like for instance, it would be unreasonable for a landlord to ask somebody who's wheelchair bound, why do you need assigned parking? Like that wouldn't make sense. But for instance, somebody where the disability is not as obvious, and a lot of times mental illness isn't as obvious, then the landlord must ask for reasonable documentation. And that could be something from the person's a professional healthcare provider, but they do not need to disclose their diagnoses, their the nature of their disability, and they do not have to give an entire medical history. So just enough documentation to show that there is some disability and it's a link between what asking the landlord to accommodate them with is sufficient. So the extraneous documents, those type of things, can also be a way of, in other words, avoiding somebody's request,
Right.
ignoring their request, or downright not honoring their request. And we have those issues come up a lot.
Yes.
So when you are making your request, the accommodation has to be necessary. So it actually has to be something that you need, and it has to be reasonable. That is always going to be an issue. You can't ask for instance, a reduction in your rent just because you're disabled. There's no link between you needing to have your rent reduced and the fact that you might have diabetes, for instance.
Right.
But on that note, when it comes to rental payments, if you do receive, for instance, Social Security disability, it's considered reasonable. Case law have said such that requesting that the rent payment due date be pushed back to the date in which you would normally get your Social Security disability payment. So actually requesting that is reasonable, may be considered reasonable for you to ask the landlord.
That's a new one. I haven't heard that one, Amanda. So now I know if we have some veterans that come say they having trouble to pay their rent because they're trying to catch it with their pay cycle, then we know that's a request we can put in with the landlord.
Yes, it is. That's what I mean by a lot of these accommodations are broad, and they really, the key is going to be linking that disability to what you're asking the landlord to do, linking it to the accommodation that you're requesting. And so in these instances, the landlord must accommodate you to preserve the tenancy, meaning reserving or exhausting all of their reasonable accommodation policies. So they must help you come up with solutions. Like everything might not be easy. Like for instance, we had one client who had extreme sensitivity to allergies. Her situation was a little bit rare. And it was a situation where the landlord was trying to make some accommodation by changing the air filter, doing things like that. But we have to consider what's necessary, what is practical, and what's reasonable in requesting accommodation.
Right. Do you think it's a reasonable accommodation if I have a support animal and they charge the monthly fee? Is reasonable to say I shouldn't have to pay that additional fee for my service animal? Is that a reasonable?
You're correct, and actually, HUD notice requires under reasonable accommodation for service animals that landlords waive their pet fees, and they're waiving their whole pet policy in order to accommodate a person with who needs an emotional support animal, which includes not charging them a pet fee or evicting them for unauthorized pet in the apartment. I've seen that happen too.
Wow, look, this is some good information because we've had this come up actually recently with the pet actually, and it was a emotional support. And so now I know, look, I got something to kind of go back and negotiate with.
Yes, yes. The whole purpose is that the landlord and the person making the request can come up with something that's going to help the disabled person get actual equal use and enjoyment of their home. So you may have to go back and forth. They may recommend some things. You might recommend some accommodations, or the disabled person might recommend some accommodations that's better. So it is a process where both have to communicate and be working together. So let's talk about if your request is denied or ignored, which is you've mentioned that that I've heard that happening a lot with disabled veterans. So we always recommend that you document the details, meaning if you make the request in writing, which is what we prefer, although it can be made in oral or made orally, that you make a copy of that request, that you make sure you save all correspondence between yourself and the housing provider. Make sure you have copies of your medical verification if needed, or documentation. In case you do have to file a HUD complaint. Filing a HUD complaint is an option that you have if you feel like your fair housing rights have been violated, particularly disability. You must remember that the complaint has to be filed within 1 year of the incident happening. So that's why it's required to, that's why it's so important to have documentation so you can keep of when things have taken place, when they occurred, the dates, and that sort of thing. Typically, when you file a HUD complaint, it'll be referred to an intake specialist who might give this disabled individual call. That's when they start their investigation. They will usually interview the parties involved, and that would be the person who is accused of having been discriminated and the person who is accused of discriminating. They will try to attempt some type of conciliation or mediation between the parties to work it out. Or HUD might have to move forward with determining whether or not there's cause or for cause for charging the particular housing provider with a fair housing violation. Oftentimes, HUD will transfer the complaints to a local agency, in this case, the Texas Workforce Commission. They have a civil rights division that enforces fair housing. So a lot of times HUD will refer, if you file a HUD complaint, they'll refer it sometimes to TWC because they get so many cases. But you also have the option to file directly with TWC if you wanted to. You can do both. And they have their own process and way of investigating and determining if there's been a violation. Alternatively, you can file a civil suit. You can file a civil action in federal state court based on violations of fair housing.
And normally, for an apartment complex, can you find their different violations readily available online if someone is known for fair housing violations?
So, and that's why it's important that where I discussed it earlier, some examples of what fair housing violations look like. I know a lot of people may have experienced it and didn't know that they were actually had experienced a fair housing violation. And let's see if I go back to some of the examples. And a lot of these aren't going to always be blatant,
Right.
I've seen things happen where, like, setting different terms, stuff like that, it's not going to say, well, I haven't seen any. at this time and day, no Blacks are allowed to rent here.
Right.
But they might use other phrases, they might do other things to deter Blacks from applying or prevent them from renting a particular home. And so those are factors, those are things that you can look at to determine if there's been a fair housing violation. We're talking specifically about disability, but those people who are classes who are protected under fair housing also includes race, color, religion, family status, and I talked a little bit about what a familial discrimination in housing might look like preventing somebody who's pregnant from renting or making rules or advertisement that might, be implied that, we're only taking families of 2 or 3, that sort of thing. So some resources that disabled individuals can use, even veterans, disabled veterans could use, is I've copied some direct links to the HUD complaint and how to file a HUD complaint, how to submit a complaint through Texas Workforce Commission. And then also Texas Law Help is very helpful. It has a lot of legal information and forms for which people could use to help them in determining if they've been, if they've been violated of a Fair Housing Act. They have a Fair Housing Act issue. And then, of course, they can reach out to Lone Star Legal Aid. They can call our intake, and they can even apply online. Online is probably more helpful to a lot of individuals, but you can always reach out to us to assist with, what you might perceive as a Fair Housing Act violation. And if you qualify for our services, we'll be more than happy to help. So did you have any questions, Delilah?
I really didn't have any more additional questions. I'm trying to think if I had any more fair housing. I know it comes up so often with different small things. Well, like you said, we can find those. If someone is a property that has multiple violations, we can find that information online about their property. Like if we want to vet a landlord before we send a veteran over there. Is it anywhere we can go online and look up to make sure they don't have any violations or?
I don't know the specific answer to that. Realtors might have, they might have some insight or know of a list that might exist of, properties where landowners have a bad reputation or they're not good with working with tenants. It's not something that I have specific access to or know of a list of anything like that, but maybe I'm thinking realtor might be, realtors typically have some type of insight and can refer people because they hear a lot more of these situations in terms of helping people to seek homes.
Right. Yes, well, thank you. I feel like I'm more informed with fair housing and ready to help someone. Look,
Awesome. Well, thank you. And thank you for sharing the experiences of the veterans who you work with. And I hope this information helps them.
It does. We have a question that just popped up, if I can see it. It says, what about prior convictions? People on low income often lack resources for adequate legal defense. If charged with an offense, court-appointed attorneys are pressured to move quickly. Unfair convictions often occur, and low income communities are vulnerable to this, plays into discrimination. So anything with convictions fall into that, and low income fall into anything with fair housing?
So, I mean, in terms of what we're talking about today, no, we're talking specifically about disability. We talked a little bit about fair housing in general, but I know that it is legal for landlords to use certain factors in determining whether or not to approve an application. So they might look at convictions, but that is a fine line between, you know, screening for certain things for which they're allowed to screen for, and discriminating on individuals based on color. So for instance, there might be situations in which a landlord say, I don't rent at all to
Sex offenders.
individuals who have convictions, all right?
Right.
And that might be a claim for fair housing, you know, complaint, just because the majority of individuals who have convictions are African American. That might be a race-based discrimination. But generally speaking, landlords do have a right to consider, just like they can consider credit score and other factors in determining whether or not to approve an application for housing.
Trying to see. Do we have any other questions online? Let me see any coming through. No. That was the last
Looks like
question.
that-
Oh,
Oh,
I think she said
oh,
just, just the one. Okay.
okay. Thank you so much, Delilah. Thank you, everyone. Please remember that this was just for education purposes, not intended to give specific legal advice. If you need specific legal advice, please reach out to Lone Star with the information provided. Or you can reach out to Delilah and their services, specifically if you're a veteran.
Yes. Thank you.
Thank-
Thank you, Amanda.